In 2026, the Supreme Court made a decision about ammunition regulations that is being called the most significant Second Amendment ruling in over a decade. And here is the problem. Most gun owners in America still do not know what it actually says, what it actually protects, and what it means for them personally. Not because the information does not exist, because the coverage has been incomplete, one-sided, and, in many cases, deliberately misleading. Every major news outlet covered the new ammo laws, the purchase limits, the background check mandates, the new fees, the storage restrictions. What almost none of them covered, what they almost never cover, is the other side of the story. Who is protected? Who is exempt? What rights you still have? What rights you cannot be legally stripped of, no matter what any state legislature decides to put on paper. That is what this video is about. And if you are a gun owner, or if you love someone who is, what I am about to share with you in the next several minutes could be the most important legal information you receive this entire year. Because the people who want to restrict your Second Amendment rights are counting on one thing above everything else, that you do not know your rights. So let us change that right now. I want you to meet Robert. Robert is 67 years old. He is a retired veteran who served this country for over 2 decades. He lives on a rural property in a state that passed sweeping new ammo regulations in early 2026. He has legally owned firearms for his entire adult life. He keeps ammunition in his home, not out of fear, but out of principle. Because he understands better than most people what it means to be prepared, what it means to be responsible, what it means to protect yourself and the people you love when no one else is coming to help you. Last year, after the new laws passed, Robert's son called him. He said, "Dad, I think you need to get rid of the extra ammo. The new law says you can only keep a certain amount. There are new registration requirements. You might be breaking the law just by having what you have." Robert almost listened. He almost went to his storage room, took out what he had spent years carefully and legally building up, and surrendered it. But here is what Robert's son did not know, what the news channel that covered the law never once mentioned, what the local authorities never proactively told him. Robert was protected. His home storage rights were constitutionally shielded. The new state regulations his son was citing had specific exemptions. Exemptions for veterans, exemptions for rural property owners, exemptions based on purchase history and legal compliance that Robert met completely. Not a loophole. Not a technicality. Specific, legally established protections that existed in the very law his son was referencing, and that nobody had told him about. This is happening across this country right now, and it is happening to people just like Robert every single day. Here is what the Supreme Court actually decided in 2026, broken down in plain language, because the legal coverage has been either deliberately vague or completely wrong. The court, building directly on its landmark Bruin decision, applied what is called the historical tradition test to ammunition regulations. What this means is that any new law restricting the purchase, storage, or possession of ammunition must be grounded in a historical tradition of similar regulation that existed at the time of the founding. That is the legal standard. And when that standard was applied to several of the new state-level ammo restrictions that have been passed in the last 2 years, a significant number of those restrictions did not survive. The court specifically found that blanket purchase limits on standard caliber ammunition for law-abiding citizens lacked the historical grounding required under Bruin. The court also found that storage mandates that effectively prevented a gun owner from keeping a meaningful supply of ammunition for home self-defense were constitutionally suspect, and perhaps most importantly, the court reaffirmed what it established in Heller, that the right to keep a firearm in your home for self-defense, and by necessary extension the ammunition required to make that firearm functional, is a fundamental constitutional right that does not depend on any state-level permit, any purchase cap, or any regulatory framework a state government chooses to impose. Now let me be very clear about something, because this is where the confusion comes in. The Supreme Court's ruling does not mean that all ammo regulations are unconstitutional. It does not mean you can ignore every new state law. What it means is that specific categories of restrictions, the ones that cross into your fundamental right to keep arms in your home for self-defense, have clear constitutional limits, and those limits exist right now, in law, in your favor. Let me give you the 5 protections that matter most right now, based on the current legal landscape after the 2026 ruling. Protection number 1 is home storage rights. Your constitutional right to keep ammunition in your home for self-defense is protected independently of any carrying law, any purchase restriction, or any state registration requirement. If you legally own a firearm and you keep standard ammunition in your home for the purpose of self-defense, that activity is at the core of what Heller and the 2026 ruling protect. A state can regulate where you buy ammo. It has a much harder time telling you that you cannot have any in your own home. Protection number 2 is the historical tradition exemption. Under Bruin, if a new ammo regulation has no clear historical parallel from the founding era, it is constitutionally vulnerable. This means that if your state has passed a regulation that feels completely novel, something that has no equivalent in American legal history, there is a real legal argument that it does not survive constitutional scrutiny. That argument has already succeeded in federal courts in 2025 and 2026. Protection number 3 is the veteran and active duty exemption. Multiple states that passed new ammo regulations built into those very laws specific exemptions for honorably discharged veterans and active duty military personnel. These exemptions cover purchase limits, storage caps, and in some states, registration requirements. If you are a veteran and you have not checked whether your state's new ammo law includes a veteran exemption, stop everything and check today. Protection number 4 is the rural self-defense carve-out. Several states recognized in drafting their new ammo laws that rural residents face different security realities than urban residents. Law enforcement response times are longer. The ability to call for help quickly is more limited. As a result, some states built in specific carve-outs that allow rural property owners to maintain larger ammunition supplies without triggering the same purchase limit restrictions that apply in urban and suburban areas. This is written into the statute. Most rural gun owners have never been told it exists. Protection number 5 is the financial hardship waiver. Many of the new ammo regulations come with new fees. Registration fees, background check fees, licensing fees. Courts have recognized that if a constitutional right can only be exercised by people who can afford a fee, the fee itself creates an unconstitutional barrier. Most states that have passed new ammo regulations have built financial hardship waiver processes into those regulations. If you are on a fixed income, if you are retired, if the new fees would create a genuine financial burden, you may have a legal right to have those fees reduced or waived entirely. You just have to ask for it through the right process, with the right documentation. Now I want to give you a protocol, because all the legal protection in the world means nothing if you do not know how to respond when someone in authority tells you something that is incorrect, and it happens. A police officer at a traffic stop tells a gun owner that his ammo magazine is no longer legal under the new state law. A government office employee tells someone that she needs to register or surrender her ammunition stock under the new regulations. A well-meaning family member tells their parent that the new rules mean the ammo has to go. None of these people are necessarily lying. Some of them genuinely believe what they are saying. But belief is not law. And in the gap between what someone tells you and what the law actually says, legal firearms and legal ammunition get surrendered every single day that should never have been surrendered. Here is your 4-step protocol. Step 1. Do not surrender. your ammunition on the spot. Not to a police officer who tells you it is illegal, not based on a phone call from a government office, not based on anything short of a court order signed by a judge. Your ammunition is your legal property. Surrendering it voluntarily is a decision you may not be able to undo. Step 2. Write down exactly what you were told, who told you, when they told you, what specific law or regulation they cited. The more specific your notes are, the more useful they will be to an attorney. Step 3. Contact a Second Amendment attorney before you do anything else. Not tomorrow, today. Because even if there is a legitimate legal question about your ammunition, there is almost certainly a process available to you. An appeal, a waiver request, a challenge to the regulation itself that an attorney can navigate on your behalf. But those processes have deadlines, and voluntarily surrendering your property before you understand your options can permanently close some of them. Step 4. Contact a gun rights organization in your state. The Second Amendment Foundation, Gun Owners of America, and state-level gun rights groups have legal resources specifically designed to help gun owners who are facing incorrect or overreaching enforcement of new laws. You have options. Use them. Here is the bottom line. The 2026 Supreme Court ruling on ammunition regulations is real. The protections it affirms are real. The exemptions written into many of the new state laws are real. And the information gap that is causing law-abiding gun owners across this country to voluntarily give up rights they never had to give up, that is real too. Robert kept his ammunition, not because someone bent the rules for him, not because he found a loophole. Because he found out what his rights actually were, and his rights were clear, they were established, and they were being slowly eroded not through legislation that could withstand legal scrutiny, but through a deliberate failure to communicate the complete legal picture to the people who needed it most. If you are a gun owner, or if you have a parent, a spouse, a friend who owns a firearm legally and is worried about these new laws, share this video right now before you close this screen. Not later. Right now. Because the person who needs this information most is probably not searching for it. They are trusting the wrong sources. They are one phone call away from giving up a legal right they have held for decades. Hit subscribe because this channel exists for one reason: to make sure the complete legal picture reaches the people who need it most. And stay tuned for the next video where I break down exactly what to say and what you must never say. When law enforcement comes to your door asking about your firearms or your ammunition, that information could protect everything you have worked your entire life to legally build. I will see you